Good evening, all, and I want to thank you for joining us. Let me start off by saying the COVID-19 pandemic precipitated catastrophic job loss, high unemployment, and severe economic hardship in renter households, and is equally echoed by small landlords. As a result, the risk of eviction increased and worsened during the pandemic, particularly among communities of color and low-income communities. Unfortunately, prior to the onset of this pandemic, housing insecurity was fragile in many cases already. New Yorkers had lived paycheck to paycheck, but now find that jobs, once sustaining, have now ceased to exist, are unstable, or are in danger of extinction by the current crises. We are concerned that many may slip through the cracks while they are trying to get help but don't know where to start, along with trying to focus on surviving the crises themselves or helping their family, friends, and neighbors to do so as well. Tonight, we are joined by some of the most respected professionals in the city of New York. Satish Nori of the Queens Legal Aid Society will moderate, followed with the presentations by the Legal Aid Society, Housing Court Answers, JASA Legal Services for Elder Justice, NILAG, known as New York Legal Assistance Group, also known as NILAG, I got that backwards, the Office of Civil Justice, Human Resources Administration, also known as HRA, the Mayor's Office to Protect Tenants, and last but certainly not least, the Office of New York State Attorney General Letitia James will be speaking and will field questions tonight. We're excited to get the most accurate information out to as many New Yorkers as possible. And now it is my pleasure to turn over to Satish Nori. But let me just say before she comes on, is if you're someone suffering right now, please know that there's assistance out there. You don't have to suffer in silence. If you are fighting any legal battles or landlords, don't do it alone. Don't go alone. I always say this to people, do not go at it alone. There are organizations that are reputable, that do great work each and every day, who you should work with and contact so that you're not going up against the system alone. So that's it. There's nothing you remember tonight. That's the one thing I want you to remember, is that you have help, and they're all here tonight. And before I turn it over to Ms. Nori, let me go to my colleague. I see we're joined by Councilmember Barry Grodenchik. I think his background is at Borough Hall, but I haven't seen him at Borough Hall today at all. But I good to see you. So Barry, if you want to give a few words, if you learn how to unmute yourself, or I think you muted, you're not moving. All righty, your eyes are moving now.
I really want to thank you. Oh, can you see me now?
I see you now. Yeah, you're at Borough Hall.
Okay, I really want to thank you for putting this together. And, this is perhaps the most critical issue facing our city. And I know it's an issue that you and I have discussed from time to time. But I really want to thank you for putting this together, and we have got to keep the pressure up on City Hall and on the White House, because we cannot have a housing eviction pandemic. We cannot have people anytime. And so I'm happy to join with you tonight. I'm like an octopus tonight out of Zooms, but I did want to stop by and thank the borough president for organizing this. And I hope that many good things come out of this. So thank you, Borough President. And
Thank you. Thank you, Barry. And he's totally correct. We know that there's a moratorium right now, but we know the courts will open up one day. So we all have to be prepared and put on our armor and get ready for this battle ahead of us. So with that being said, I'm going to now turn it over to Ms. Satish Nori. And thank you for being here.
Thank you, Borough President Richards. It's a pleasure to be here. We have a powerhouse panel of speakers representing city, state, and private agencies who are here to serve the residents of Queens, also the rest of New York City and the rest of the state. We are in the middle of a pandemic, but housing is critical to us coming out of this pandemic healthy and safe and strong. And unless we protect housing for tenants and homeowners, the pandemic isn't going to go away. we're going to have a public health crisis that repeats itself, and we're going to have a new pandemic, which will be a wave of homelessness and all the consequences that come from that. So with that, let me turn it over to our first set of panelists. I would like to introduce Jordan Dressler and Kenneth Charles from the Human Resources Administration. Jordan?
Thank you, Satish. And I want to thank Borough President Richards and your team for including us tonight. This is a critical time to be discussing the rights of tenants, the resources for tenants. Most of all, I want to thank and tip my hat to my fellow panelists, those particularly working with legal services organizations that we support. We have never been prouder to support you and your important work here at the Office of Civil Justice. I have a brief slide deck just to help guide the discussion that I'm going to share as soon as I figure out how. Bear with me, please. Where is? Whoops. There we go. Thank you. So my name is Jordan Dressler. I am the City Civil Justice Coordinator. In that capacity, I head up the Office of Civil Justice at the Human Resources Administration. We are a relatively new office. We were established in 2015, and where are we now? Thank you. What we do is provide free legal services to New York City tenants facing eviction, harassment, disrepair, and other housing-related issues, in addition to also providing legal services in the areas of immigration, low-wage workers. I'm not going to spend a lot of time talking about the work of my office, but primarily what we do is both support the legal services organizations who are actually doing this work, nonprofit legal organizations that may be citywide, they may be borough-based, they may be small and local. But we support them with funding and other support, and also coordinate among the various stakeholders in the civil justice system, and in particular the housing justice system, acting as a liaison and air traffic control with the courts, tenant advocacy groups, legal services providers, and other city agencies, including the Mayor's Office to Protect Tenants, who's here with us tonight. Probably our signature initiative is implementing the city's groundbreaking right to counsel law. We all know that if you are charged with a crime, or if you are a parent or guardian accused of abuse or neglect, you have a right to an attorney. In nearly every place in this country, if you are facing eviction, that is not the case. But here in New York City, since 2017, it is the case, and we have been implementing the city's right to counsel law as the first and largest city in the country, working to ensure that tenants facing eviction cases have access to free legal assistance. We are working with nonprofit legal services organizations to provide access to free legal help for tenants facing eviction in New York City Housing Court, as well as tenants who may be in administrative termination of tenancy proceedings in the New York City Housing Authority. In addition to providing free legal assistance to tenants facing eviction, we also facilitate legal services for tenants facing other kinds of issues, whether it's tenants in need of help in individual or group collective litigation to help maintain and preserve their housing, and most of all, to protect them against harassment, disrepair, or other misconduct by unscrupulous landlords. I want to be clear about this. OCJ's legal services are available citywide, and they're available regardless of your immigration status. As far as the city's right to counsel law goes, again, we've been implementing this since 2017. The way the city's law works, city-funded legal services are available to all tenants facing eviction proceedings in housing court or NYCHA proceedings at or close to the first appearance in court. Legal representation, meaning an actual lawyer in court with you, is available for tenants whose households are at or above 200% of the federal poverty guidelines. As of now, that's approximately $53,000 a year for a family of four. And for those who are earning more, brief legal assistance is available. We've been implementing this up through the beginning of the COVID pandemic on a zip by zip basis, which is to say that tenants, in particular high need zips across New York City that we've selected in partnership with advocates and others based on high need factors, have been assured that they have had access to legal representation. While across the city, tenants who are facing eviction have had access to legal representation subject to the capacity of legal services providers that we work with. We've been rolling this out for approximately 3 years now. We expect to be fully implemented in 2022. And we really have, we think, had an impact. And when I say we, I really mean the legal services providers who are joining us today, who are actually on the ground doing this work. I want to just set the stage here. Back in 2013, only 1% of New York City tenants had a lawyer in housing court if they were facing eviction. Flash forward to the end of 2019, again before the pandemic, and citywide, fully almost 40% of tenants had legal representation at their housing court eviction case. And in those neighborhoods that we've targeted for, that we had been targeting for right to counsel treatment, that was 2/3 of tenants in those households, in those cases, had legal representation. And the impact has been considerable. Evictions have dropped year over year. Back in 2019, the evictions were as low as 17,000. Flash back to 2013, and they were as many as almost 29,000. And even the number of cases being filed in housing court has been dropping year over year over year. So we've been thinking that we're on the right track. We're very grateful for the partnership of our legal services organizations working with us to do this work. All of this feels a bit like ancient history because all of this predates the COVID-19 pandemic, but we learned a lot of valuable lessons. And we learned that if we work together and stayed in close partnership with legal services providers and the courts to make sure that we were implementing legal services on the ground, in the community, and at court, either virtually or physically or otherwise, that we could have an impact and ensure that that tenants who were in need of legal services would be able to get them and get them widely, get them easily, and get them effectively. So during the pandemic, we have pivoted as everyone else has. And at this point, tenants citywide with questions or concerns about an unscheduled eviction case, one that hasn't yet been brought to court, with lease issues, or with other landlord-tenant matters, can call the city's tenant helpline via 311, and they can be connected with live phone-based legal advice through one of our nonprofit legal services partners. You're going to be hearing more about the city's tenant helpline from the mayor's office to protect tenants later in the presentation. Tenants who are facing emergency cases or wish to bring emergency cases, tenants who are locked out of their homes without a court order, tenants who are seeking emergency repairs from their landlord, tenants who are seeking critical services like heat or hot water, they have access to free legal representation, regardless of their zip code, regardless of their income, regardless of their immigration status. Tenants responding to a marshal's eviction warrant or a landlord's motion for such a warrant also have access to free legal representation, regardless of zip code, regardless of immigration status, regardless of their income, with a waiver by my office. Tenants who are facing eviction proceedings right now, in the midst even of this current freeze that comes from the state law that we'll be talking about, because they are alleged to be causing a nuisance or an unsafe condition, they too have access to free legal representation. That's true regardless of their zip code, their immigration status, or their income. We have worked closely with the courts. We have worked closely with legal services providers to ensure that every tenant who is facing an eviction case now is able to access free legal representation. And as the courts move forward with reopening, we will be working with our partners to ensure that tenants who are facing eviction in housing court have access to the legal services they need. The question may be how to get access to those legal services now. One of the things that we did was ensure that when tenants are appearing in court or responding to court processes, that they have access to legal services in connection with the court. So legal services are available for unrepresented tenants in the actual court conferences, whether that's an appearance by teleconference or in person. You can call our partner Housing Court Answers. Jenny Laurie, the executive director, is on with us tonight and will be giving a presentation. Their numbers are here and we can put them in the chat so you don't have to scribble them down. You can call 311. You can ask for the tenant helpline. You can also email us at the Office of Civil Justice. And finally, you can access our website at nyc.gov/RTC for Right to Counsel for a list of the nonprofit law offices near you that provide legal help for tenants. So with that, again, I want to say thank you to the Borough President for convening this group to have this important discussion. And most of all, I want to thank our partners here in this panel who are out there fighting and defending the rights of tenants in the streets, in the community, in court. Thank you.
Thank you so much, Jordan. Many of us here wouldn't be here without the support of the Office of Civil Justice. Let me turn it over next to Juan Venero and Olivia Amezcua from the Mayor's Office to Protect Tenants.
Thank you, Satish. Good evening, everyone. I would like to start off by saying thank you for President Donovan Richards for having us here today, as well as all the other panelists also joining us. Today, I am with my colleague, Olivia Amezcua, and we're here today to talk about the resources that our office, MOPT, has available for tenants in the light of COVID-19. Let me go ahead and share my screen with you guys. Okay. So very quickly, before I do begin to discuss on the resources that we're here to talk about today, I do want to take a second and first just introduce our office to those who are not familiar with MOPT. We as well are very relatively new. Well, we were created back in January of 2019, and we serve as a core part of the city's strategy to confront the affordable housing crisis. Our office works across with other city agencies to make existing anti-harassment and anti-displacement programs better, and also to create new strategies to root out abuse. So today we're here to discuss on three main resources that our office has available at this time in light of COVID-19 for tenants who are in need of help. First would be our online resources that will be available within our website. And then, as Jordan also mentioned, we're going to be discussing a bit more briefly about the tenant helpline. And then we're going to also then segue into our tenant resource portal. So at this time, I'm going to go ahead and pass this along to my colleague, Olivia, who's going to go ahead and quickly run down through the first couple resources here.
Thank you, Juan. I will begin by going through the list of some of our online resources, which can all be found on the MOPT website under the Resources tab. So we have general information on tenants' rights and resources. We also have a fact sheet for tenants impacted by COVID-19, translated into these 10 languages. And here is where you can find the most recent updates to the eviction moratorium, information about eligibility, and details about the hardship declaration. We also have an eviction prevention brochure. And then we have our tenant resource portal, which is an interactive resource that helps tenants figure out what to do if they are at risk of eviction. And we are going to go over that resource more in depth later in the presentation. You can visit our contact us page to send us a message. And lastly, you can follow us on Twitter at NYC-MOPT for regular updates. And we are happy to share links to these resources and any PDFs or images that we have in relation to these resources. And like I mentioned, all of these can be found on our website. We will now go over the tenant helpline, which is a resource put on by us, the Public Engagement Unit, and the Office of Civil Justice, who we just heard from. But the tenant helpline connects tenants with tenant support specialists who can help renters navigate their individual situations. So to access the helpline, dial 311 and then ask for the tenant helpline. Tenants will be able to talk with a person who is a tenant support specialist. It is language accessible, And all New York City tenants are able to use the helpline, regardless of income, immigration status, or zip code. The helpline functions as a warm line, so tenants will call 311, ask for the tenant helpline, and leave a message with their name and contact information. And then a tenant support specialist will call the tenant back, usually within 3 business days, to assist them. And if you don't feel comfortable leaving a message, you can fill out a form on our website and you will get routed to the same tenant support specialist as you would if you had left a voicemail. Tenants are able to call the helpline for many different reasons. They help with providing resources on tenant protections related to the pandemic, general information on tenants' rights. And as was mentioned before, the helpline can help tenants access free legal services and refer folks to landlord-tenant mediation services. Specialists can help tenants understand their leases and fight rent overcharges, and also help them get repairs made in their apartment. Tenants are also able to work with the city to pay rent arrears. And specialists can also help tenants access additional public benefits that they may be entitled to but are not currently getting. The helpline can also assist renters fighting landlord harassment and discrimination. And specialists can also help people understand the evictions moratorium, their eligibility, and help them with filling out the hardship declaration. So the tenant helpline can be an important resource for folks if you need help navigating the moratorium. I'm now going to pass it back to my colleague Juan, who is going to discuss the tenant resource portal.
Thank you, Olivia. So now we're going to center our focus on our last resource that we're here to speak on, which is the New York City Tenant Resource Portal. The Tenant Resource Portal it's the first of its kind and was launched back in July of last year and was created as a way to provide tenants across the city with the proper resources and information that they will need to remain stably housed. So the Tenant Resource Portal is the city's first ever online self-service portal to help residential renters access free resources from the city to help prevent evictions. So the Tenant Resource Portal has been a work in progress for many months now. Of course, early last year when COVID hit, we began to pivot our focus on this portal to be more centered on the housing courts and eviction moratoria. At this time, we're currently working on phase 2 of the portal, which will include more comprehensive subject areas that will help address other needs for tenants as well. So the Tenant Resource Portal also features an eviction prevention tool to help renters navigate free public and private resources that can help stabilize their housing situation. So we've gathered many resources from other city agencies, we also from other community-based organizations to create what we consider as this one-stop shop that will provide information and guidance needed for all tenants. We've worked closely with our partners over at the Public Engagement Unit as well as the Tenant Support Unit to transcribe the call structures that they usually get on the 311 helpline. And we've basically turned that into a web format, which is actually the first time that that's ever been done as well. So the mission of the Tenant Resource Portal is to help tenants better understand the realities and the issues that they're facing, and of course to provide immediate, reliable, and up-to-date information about the resources that can help them overcome these issues. So the portal itself is very user-friendly. The way it works, it navigates the user through a series of questions to better understand the tenant's issues at hand. We strongly encourage that and recommend for all tenants who do visit the portal to answer the questions as honestly as possible, of course, to receive the best information and resources to help them. We also encourage that when you do receive the guidance in the end of the page, when you do answer all questions, that you do take the time to read thoroughly throughout all the information that's provided. Of course, our office has exhausted all resources available to provide and present these tenants with the list of important information and guidelines that would help them teach and better understand the protections that they have. So usually at this time, what we would do if we had more time, of course, due to constraints we would normally do a live demo of what that resource portal would look like. However, we're going to just go ahead and jump ahead of that. So once you answer the questions that the portal will ask all users, the first set of guidance that the user will be presented with is gonna be about the facts around the eviction moratorium and the courthouse closures. So regardless of whatever answer the user provides, we've made sure that we've escalated those actual information and updates as being the first form of information that all tenants and users get when they do access the portal. The rest of the guidance that is offered on the page is organized based on the answers, of course, that the user provides. And the way that the portal is designed is it's designed to weed out all the other issues and try to narrow down the information and guidance that most relevant to the user and based on the information that they've provided, of course. Now, we also understand that if a tenant has not figured out a solution to their problem, or if they're still confused based on the guidance that they've received, that there is an option for them to be connected with a tenant support specialist as well. So at the very end of the guidance page, at the end of the portal, you'll see that there'll be a link as well that would say, I still need help. That would redirect the user to a form that would allow them to fill out all the basic information that they would need to be contacted, such as name, street address, phone number, email, and also leave a brief description as well. But the good thing about the portal itself is that when you do provide that information at the end, when you click on I still need help, that information gets forwarded as well to the tenant support specialist, which will be able to gather all the information already provided, as well as more in-depth understanding of what the tenant is in need of, which means when the specialist contacts the tenant within the 48 to 72 hour period, they will have already more information and the tenant will not have to go and reiterate themselves in terms of what they need help on. So that's the great thing about the portal itself. So just to reiterate a little bit more about the tenant resource portal, of course, our goal here is to help New Yorkers stabilize their housing situations and to provide information that would help them alleviate the stress and uncertainties, especially in the light of COVID-19. As I mentioned also, we've pivoted our focus over to the housing courts and eviction prevention resources. So we've been working very closely with the Office of Civil Justice as well as City Hall to constantly update these new guidance when they are released. And as I mentioned, this is also this first city-hosted platform where tenants at risk of evictions can go and get the resources they need. So we do strongly encourage everyone to visit the portal and give it a try. And the portal itself is accessible to anyone who has internet access. There's no need to create any login information or have to create any sort of email to do so. Of course, for those tenants who have no access to the internet, they can also call 311 and ask for a tenant helpline, and they would also be able to receive the same information available as well. I'm going to just go back to the last slide because I did have the link below. Under the actual graphic that you see there that we initiated when we were campaigning for the resource portal, we have the two direct links to that tenant resource portal. We have the first one, which is for English version, which is nyc.gov/tenant resource portal. And we also have the Spanish available version translated, which is nyc.gov/portal para inquilinos. At this time, under our phase 2, we're also working in hopefully getting other languages also accessible within the resource, the portal itself. I do understand that for some browsers, for example, Google Chrome, you can add an extension that could lead on to translations. However, we do just want to make sure that we consent that we do not know if the translation will be 100%. So, but by any means, if there is a language barrier and you have the access to the add-on, we do suggest and recommend for users to do that as well. But that is all for today that we have in regards to the resources that we have available. And we have, as Olivia mentioned earlier, we have links, PDFs, toolkits, and much more available to resources to provide to all partners who would like to also spread this news and resources to their to partners and other tenants as well. And this is all we have for today. And thank you for your time.
Thank you so much, Juan and Olivia. I want to thank the Mayor's Office to Protect Tenants. They've done so much in a short period of time to really reach out on tenant issues, and they've done some real cutting edge things to protect tenants in New York City. So I want to thank you guys. So now we're going to move into some of the laws that are on the books to protect tenants. And I'm going to start with Hannah Fishman from NILAG, who's going to talk about housing protections and the harassment laws.
Good evening. Thank you to the Borough President for organizing this great event. And thank you for including me. So I'm going to quickly share my screen here. All right, so I am a supervising attorney at the New York Legal Assistance Group. We are a nonprofit organization providing free legal services, financial counseling, and policy advocacy for people experiencing poverty in New York City. We wanted to, as part of this presentation, today is going to be mostly focused on foreclosure and eviction and the moratorium that is protecting people and keeping them in their homes mostly. There are, as you'll learn today, there are some exceptions to that. But that doesn't mean that the courts are closed entirely. There are options available and protections available to tenants that they can exercise in order to not only make sure that they remain in their homes, but also that they have a safe, habitable environment to live in. So I'm going to start today talking a little bit about illegal lockouts, which have been on the rise since the pandemic has started, as landlords have been seeking alternative forms of relief to try and get people out. So first, it is absolutely illegal for your landlord to just decide one day to lock you out of your home. As long as you have lived in your apartment for more than 30 days, paid rent, or had a lease, you are entitled to remain in your home until a court says otherwise. Your landlord must begin a court case against you, get a judgment of possession against you, and request a warrant of eviction. Only a marshal or sheriff can evict you. So if your landlord comes knocking at your door and tells you to leave, that doesn't mean you need to leave in that moment. In fact, you should not. You are permitted to stay in your home until a court says otherwise. So even after a judgment of possession has been entered in against you, you are also entitled to additional notice at that point. If your case was filed a long time ago, if it was filed before June of 2019, then the marshal will have to give you 6 business days worth of notice before they can proceed to an eviction. If the case was filed after June 2019, then they have to give you 14 calendar days worth of notice. And even then, it doesn't necessarily mean that you are going to be evicted. You have the option of going to housing court and filing what's called an order to show cause to stay your eviction. This legal process is going, and what it looks like right now is going to be discussed later in this presentation. But if you believe you've been illegally locked out of your home, you should first contact the local police precinct for assistance getting access if you feel comfortable with that. You can then or file an illegal lockout case in housing court. You can do that via order to show cause. The way that I usually advise folks to do it is to go immediately to the housing court in your borough in order to just get the case started. Then you can call 311, use any of the resources that are available to get an attorney to help you with the case. But because of the expediency of the situation, because you need to get it done quickly, we advise you to take that step immediately. We also want you to find a place to stay. Even if you have been illegally locked out, it can take a little bit of time to get back into your home. And so you'll need to find a place to stay temporarily. So that's a bit of basics about illegal lockouts. I'm going through this relatively quickly. Happy to answer questions when we get to that portion here. We have a lot to talk about today, and so I don't want to take too much time on this piece. But another thing that many tenants face are problems with getting repairs taken care of and harassment at the hands of their landlord. Starting with repairs, every tenant has what is called a warranty of habitability. the apartment that they live in, the home that they live in, it's not just that they're entitled to the home that they signed the lease for, but that the landlord has to provide a safe environment for that home. So if you are living in, if you have no heat, if you have no hot water, if you have mold in your apartment, those are very serious problems and are not something that you just have to live with. Nor is it something that the courts are currently closed to handling. It is something that even during this COVID period, you can get help from the courts and get those things taken care of. So the way you would go about that is by bringing your landlord to court. The courts are actually prioritizing emergency cases right now. As you know, they are working on sort of limited staff. So things like no heat, no hot water, severe leaks, mold, problems with mice, rats, roaches, those kinds of really extreme circumstances are the kind that the court's prioritizing right now. If you have more minor conditions in your home, you should certainly raise those as well. Anytime you bring your landlord to court, you want to include all the allegations you can to make sure that you can get everything resolved at once. So one very important thing to do when you're dealing with repairs and having trouble getting them taken care of by your landlord is to maintain records. One of the most challenging pieces of cases where you are bringing allegations against your landlord for repair issues is proof. And so these are some ideas that you can start working with in order to keep records. I get a notebook, make it your landlord notebook, and write down all of your interactions with your landlord, when they happened, what happened, and make notes about when you contacted your landlord to tell them that there was a problem and what they did in response. Take photographs. If it's a leak and the leak keeps getting worse and worse and worse, take regular pictures so that you can show a time lapse. If you're having trouble with heat, take the temperature. They sell very inexpensive thermometers at drugstores, hardware stores, on the internet. So you can just grab them and start keeping a log of the temperature in your home. Whenever possible, you want to communicate with your landlord in writing. Again, that's so that you can have a record of the communication. I also advise that if you have bad repairs or really repairs at all, you can call 311. As you've heard, 311 is a way that you can get connected to a tenant advocate, a lawyer, but it is also a place where you can report conditions in your apartment, and an inspector from the Department of Housing Preservation and Development will come out, take a look at your conditions, and potentially issue violations against your landlords, which can come with fines. It also provides proof to the courts, if it becomes necessary, of the conditions in your home, because a neutral party will have come and taken a look. You can also, one thing that I advise as sort of a starting point in contacting before you bring any sort of case against your landlord would be to send a letter via certified mail. That way you have proof of delivery. It also shows that you have formally explained to your landlord exactly what the conditions are and what you need taken care of. And then you can start an HP action. You can do that in person. You can do that via NICEF, which is the court's online system for filing, or via this wonderful website, justfix.nyc, which has many wonderful tools available for tenants. They can help you send that certified letter that I mentioned before, and they will actually start the case for you and help you get connected to a lawyer. I recommend, if you're having any trouble with your housing, you take a look at the resources that are available there, particularly during this COVID era. The JustFix website has become very important to the work that we do. And I just included a note here: if you do sue your landlord for repairs, you should include the Department of Housing and Preservation and Development as a respondent along with your landlord. Next, I'm going to touch on harassment. I think harassment is another problem that has been on the rise during the pandemic. It is, I have the legal definition up here, but there's a little bit more detail on what constitutes harassment on this slide. So that includes violence, threats, frivolous lawsuits, removing your possessions, changing the locks, offering you a buyout after they've been told you don't want one, visiting you at odd hours, threatening you, basically any act that will interfere with your quiet enjoyment of the premises. So if you're experiencing harassment, and like I said, we've been seeing a lot of that recently. Again, one of the first things you should start doing is keeping as many records as possible. You can involve the police if that's something that makes sense for you. And you should take photos, video if that's safe for you to do, and do what you can to establish the problem. Again, that HP action is available for you here. One of the fastest ways to file those these days is again via Just Fix. You can also do so via NICEF or in housing court. And if you call the tenant helpline that was referred to, the 311 tenant helpline, you can get some advice on how to do that for your specific situation. There are also options available. The Department of Housing and Community Renewal has a complaint service for people in rent stabilized and rent controlled housing. And if you suspect you're being discriminated against because you are a member of a protected class, whether that's a racial minority, whether it's really anything, if it's because you believe your landlord's uncomfortable with your sexuality, one of the best resources there is the New York City Commission on Human Rights, which you can reach via 311. There is also a New York State Commission on Human Rights. Though if you live in New York City, I do advise that you start with the City Commission on Human Rights. And if you live in a building that is managed by a city agency or federal agency, really any government agency, such as the Department of Housing and Urban Development, again, the Department of Housing Preservation and Development in New York, they usually have complaint forms available to you that you can use to get something started. And the beauty of these organizations is that they will assign an investigator to your case who will help actually delve into the issues. They tend to be a friendlier ear than many housing court judges, and will really investigate the allegations going on in your situation. So then I have here some resources. You're hearing about them. I think every single person here has mentioned some of these, and I'm sure that will continue to be the case. But there's the 311 tenant hotline. There's Just Fix, Housing Court Answers, who we're going to be hearing from shortly. I also want to note that many of you may be finding that you and your neighbors are experiencing the same thing. You can file group HP actions together to work with one another. You can also get looped into a tenant organizer who has expertise fighting back against landlords and who will help you and your organization and your neighbors come together and form a strategy for getting what you need out of your landlord. So the fastest way to get to somebody on that would probably be to just Google the Right to Counsel Coalition and reach out, and they will connect you to somebody who's going to be able to help you. I have a link here. It's a long one, so if you don't have a moment to write it down, Google will work for you on this one. And then the New York Legal Assistance Group has its COVID-19 hotline. We are answering questions on any COVID-related issue, and have attorneys that work in a wide range of areas other than just housing. And so please feel free to reach out to us. We're answering questions on immigration, on consumer issues, on really many, many legal issues that you're facing. So my contact information is here. Thank you very much. I look forward to hearing what questions you have, and please reach out.
Thank you so much, Hannah. NILAG is one of the great providers in New York City, and please reach out to them if you need assistance. I would just stress that when we're stuck in our homes, it's more important than ever that our homes are safe, healthy, and habitable. So please reach out if you need repairs. And also, if you're facing harassment, please reach out. We are here to help you. We can fight and make sure that those repairs are made and that harassment stops. So with that, I'm going to turn it over to my own team at Legal Aid, led by Kara Smith and Michael Koyak, who are actually law students at NYU. And they're going to speak about the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020.
Thank you, Satish, and thank you to the borough president and all the other panelists for making tonight possible. As Satish explained, Kara and I are going to be talking about the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. So there are two big parts to this act. There's a part A, which is related to eviction proceedings. And those are obviously relevant for people who are renting in the city. And Kara and I are going to be talking about that. Part B of the act is actually talking about foreclosure proceedings. And that's obviously relevant instead for people who own mortgages or who otherwise have an ownership stake in property. And that is going to be discussed actually by Donna Doherty from JASA and Legal Services for Elder Justice after Kara and I talk about Part A. So a little bit of background on this situation we're in now. Obviously, the COVID situation started last winter, February, March is when things kind of got serious in the US. And so Governor Cuomo had declared COVID an emergency because of the public health threat. And there were a couple of different steps that were taken throughout 2020. There were several executive orders in March and June, and again later in the year. And there's also something called the Tenant Safe Harbor Act, which was passed. And the result of all of those things were to pause and stay evictions and foreclosure proceedings through the end of 2020. So the act that we're talking about tonight, which the name of which was on the very first slide, extended all of those previous protections from when it was passed, which was roughly the end of 2020, up through May 2021. So this law we're talking about is really kind of a continuation of some of the piecemeal things that have already been going on in the state of New York. So there were a couple big takeaways for what this law did for tenants. The first thing is that it stayed residential evictions for 60 days. So for 2 full months, eviction proceedings were put on hold. The second crucial point that hopefully a lot of people have already heard about is it created something called a hardship declaration. And what this is a form that tenants can fill out, assuming they qualify if they've been suffering some sort of hardship due to COVID. And if they fill this out, it is going to pause or stay proceedings and eviction processes up through May 1st, 2021. Now, the third important point about this law for tenants is that it is not a blanket automatic coverage because landlords are still able to evict in one of two situations. One, if there are tenants who are creating a significant nuisance. And secondly, if there are tenants who did not complete the hardship declaration. And so the important thing to understand is if someone falls in either of these two categories, they're still vulnerable for eviction. It's not that both need to be satisfied. So next slide. So we have a bunch of the text from the statute here. I'm not going to read through it word for word, but there are a couple of important takeaways. From section 2, this is just operationalizing the first component that I had talked about on the previous couple of slides, which was a 60-day pause on all eviction proceedings. So this 60-day period started in late December, and it's going to be continuing through late February, roughly the 26th. But after that, this pause is going to end, and certain types of eviction cases could actually proceed in the court system. So this next clause 3 is important because it talks about the fact that landlords have certain responsibilities related to the hardship declaration. So most importantly, when a landlord is going to provide pre-eviction notice saying that they want to evict a tenant, they are actually required to provide the hardship declaration to the tenant. So the tenant isn't responsible for going around and finding this. It's an obligation on the landlord. And relatedly, there is a primary language requirement that the landlord provides this document in the primary language of the tenant so that they are able to receive and understand what they're supposed to do with this document. Next slide. And so there are a couple of additional things that need to be included with this hardship declaration. The first thing, the landlord needs to let the tenant know where they can return the hardship declaration after they complete it. It can be returned either to the landlord or to the local relevant court, preferably both from the perspective of Legal Aid Society. The other thing that the landlord needs to provide is a list of nonprofit legal aid services that is up to date that the tenant can contact if they need help and legal advice related to how to handle the hardship declaration or other housing related matters. So again, these are nice things to see because the burden is on the landlord here to be providing this information. This next slide just provides a hyperlink to something that I think has been mentioned earlier on this evening and will maybe be discussed again. And the website is called evictionfreenewyork.org. And what's really nice about this website is it provides an online version of the hardship declaration. So even though it's the landlord's responsibility to give the hardship declaration to the tenant can also go online and complete that very same declaration here. And what's nice about this website is it will automatically send the completed declaration to both the court system and the landlord, and it will do it with certified mail, which is a more secure way that the tenant can make sure that these are actually delivered to who they need to go to. It's also, one other point I'll say, available in Spanish as well as English. And there are a couple of other websites floating around that offer this form in even more different languages, which we can maybe provide during the Q&A session if people are interested. So the next slide that we have talks about Clause 11 of Part A of the Act. And what's important about this slide is the fact that it creates a rebuttable presumption that a hardship declaration in which the tenant has selected the option indicating a financial hardship shall create a rebuttable presumption that the tenant's experiencing financial hardship. And then to go down to the other language at the bottom, the absence of a hardship declaration shall not create a presumption that a financial hardship is not present. So what this kind of complicated language just means is that it's a very tenant-friendly presumption, because once this form is filled out, the court is going to assume in the tenant's favor that it's true that they are suffering from some financial hardship during COVID. And conversely, if the form is not filled out, the court is not going to hold that against the tenant in terms of making an opposite presumption. So that's something that we really like to see as legal aid society, because it's a very tenant-friendly clause. And then the last slide that I'll talk about here before handing it over to Kara is about the impact that the hardship declaration has on new cases. So the crucial point that I hope a lot of people are already aware of is that tenants are allowed to fill out this hardship declaration before they even get served with any sort of eviction notice. So it can be filled out proactively, prophylactically, and if that is done, it can prevent an eviction proceeding from even being initiated all the way through May 1st, 2021. Now, we're not sure exactly what's going to happen after May 1st. Hopefully the law will be extended, but it's unclear if that will be the case. But nonetheless, you can certainly see the value in at least getting it filled out now to protect for the next several months. So with that, I will turn over to Kara, who will continue for us.
Hi, everyone. Thank you all for being here. So just continuing on. So here we have a scenario where a case is ongoing. So this essentially says that if an eviction proceeding is ongoing and a warrant of eviction has not been issued, so the case is about midway through. Here, again, if the tenant provides a hardship declaration, the proceeding will be put on pause until at least May 1st, 2021. And now moving on to the next slide, we have here a second scenario. So here, the case has reached its final stages already. The landlord has already managed to secure a warrant of eviction, but the warrant of eviction has not yet been executed. So the tenant has not yet actually been evicted. So here first, there needs to be a status conference with the parties. That means the court will basically check in with everyone. And at this point, the court will ask the tenant if they have completed a hardship declaration. And here, once again, if the tenant fills out the hardship declaration, the eviction warrant will be put on hold until at least May 1st, 2021. And now on to the next slide. So this describes the affidavit requirement. So if the landlord seeks to initiate an eviction proceeding, they have to show the court that they provided a hardship declaration to the tenant and that the tenant did not complete and return it. We talked about this a little bit earlier. But basically, the landlord must swear an oath attesting that they sent the declaration and that it was not returned. And the landlord must also both show that they sent the hardship declaration to the tenant and that they sent the hardship declaration in the tenant's primary language. This part is important to note and something that we have not had before. And it's something that's especially important for Queens, where many primary residences, where many residences' primary language is not English. So that's very important to be aware of. And now moving on to the next slide. So this next slide outlines an extremely important part of the Act. the nuisance exception, which Michael talked about a little bit earlier. So here, even if a tenant has returned a hardship declaration, the landlord can still commence an eviction proceeding against them if they're engaging in nuisance behavior. So this is defined as persistently and unreasonably engaging in behavior that substantially infringes on the use or enjoyment of the space by other tenants or causes a substantial safety hazard to others. The landlord has to specifically describe the behavior alleged. It's important to stress here that the act requires that behavior be both persistent and unreasonable. So it must be more than a one-time thing. It also has to substantially infringe on the use and enjoyment of the space by other tenants or be a substantial safety hazard to others. That means if no one else is living in the building, that's going to be hard to establish. So there are a lot of components of this that's important to be aware of. And the landlord also has to specifically describe the behavior. They have to say where, what, and when, what time, what day, how many times, who was impacted, etc. They can't just say the tenant is being a pain and just leave it at that. So moving on now to the next slide. So this specifically lists out a few different ways the nuisance exception can play out. So this first section applies if the landlord had previously brought a case against a tenant about something else. So this section says that the landlord cannot just add nuisance onto the old case to try to make their case eligible for the nuisance exception. Instead, the landlord has to start a new case against the tenant if they want to allege that the tenant is engaging in nuisance behavior. They have to submit a new petition and comply with all notice and service requirements. And then section 2 here applies if the landlord has already secured a judgment against the tenant for nuisance from a case before COVID. Here, the court has to hold a hearing to see if the tenant is still engaging in nuisance behavior. And this third section just states that the landlord needs more than a mere allegation of nuisance behavior to prove that that behavior is happening. The landlord actually needs to supply proof. That could be, for example, the statement from another tenant, pictures, videos, etc. The landlord can't just say that the tenant is doing something and try and prove the case that way. Moving on now to the next slide. So this wraps up what we just talked about and what Michael mentioned before, but it is really important to understand. So section 5 here sets forth the ways in which a tenant can be evicted before May 1st. So this provides that an eviction proceeding can go forward before May 1st, 2021, if the landlord proves that the tenant is engaging in a nuisance behavior, or if the tenant fails to provide a hardship declaration. So either one of these is sufficient on their own. And then moving on to this next slide, this concerns personal service. So that's a requirement that notice be delivered to the tenant, telling them that legal proceedings have been commenced against them and providing them with a hardship declaration. So this section requires that due diligence be used to ensure that the notice is personally delivered to the tenant. Due diligence is a higher standard than we had before. It means that the landlord must make 3 attempts at personal service, that is delivering the notice to the tenant personally before they can follow the usual requirements of notice laid out in section 735, which allows them to just serve someone of suitable age and discretion at the place of residence instead of the tenant themselves. So it's important to be aware that there is a bit of a higher standard here than we had before. And now, moving on to this next section, this concerns default judgments. That means a judgment in favor of one party because the other party never responded or showed up. So this section states that before May 1st, 2021, the court cannot issue a default judgment resulting in an order of eviction without first holding a hearing after the effective date of the act, which again is December 24th, 2020. So that means that if a tenant never shows up to court and never submits a hardship declaration, a hearing still has to be held. Essentially, this gives the tenant a second chance to come to court. And now moving on to the next slide. So this pretty much sums up the most important, perhaps, takeaway of our presentation here: the situations where a tenant can be evicted prior to May 1st, 2021. at least May 1st, 2021. Again, the act may be extended. We're not sure what's going to happen. So again, the tenant can be evicted if they did not submit a hardship declaration and they were properly served with a copy of it, or if they were shown to be engaging in nuisance behavior, which is again defined as persistently and unreasonably engaging in behavior that substantially infringes on the use or enjoyment of the space by other tenants or occupants, or causes a substantial safety hazard to others. And again, that has to be proven and specifically described. And once again, either one of these is sufficient. So no hardship declaration, that's sufficient, and a nuisance behavior, that is sufficient on its own, either of those. So that's very important for tenants to be aware of. So thank you so much. And I will now turn it over to Donna from JASA and Legal Services for Elder Justice, who will be speaking about foreclosure proceedings.
Thank you so much. And thank you, Borough President, for this event. I'm going to talk about Part B of the law, which is about the foreclosure and homeowner section. So if you can go to the next slide, please. So very similar to those provisions that were in the tenant section, there is a stay of all residential foreclosure proceedings for 60 days from the act, which was at the end of December 28th, to allow the courts and mortgage companies to send out information regarding the hardship declarations. If a person owns a home and they have a mortgage and they have suffered a financial hardship similar to tenants, they can file a hardship declaration with their mortgage lender or any foreclosing party or the court. And similar to legal aid, we recommend that if there's a foreclosure going on, that hardship declaration be filed with the court and the mortgage lender. That will prevent the filing of any foreclosure action, or it'll stay the foreclosure action going on in Supreme Court until May 1, 2021, similar to the tenant section. Next slide, please. To be eligible for this, you must be a natural person. And what that means is sometimes deeds have been placed in corporations' names, limited liability companies, also known as LLCs. Those are not eligible. You must be a natural person. And you must own under 10 dwelling units. So these are for small landlords. So you can own a 2-family home, a 3-family home, and your tenant may not be able to pay you their rent. You may be having some hardship. You can file this hardship declaration. You can own one building, and maybe you own the building next door and it's less than altogether 10 dwelling units. You're eligible under this section of the law to file the hardship declaration and have a pause until May 1st, 2021. Next slide, please. So there's different types of foreclosure actions going on, and the law takes care of those. So for foreclosure actions that were filed maybe against you as the homeowner, but there's been no judgment or sale or auction yet, but yet there's an action going on, this law takes into effect those foreclosures. And again, if you file the hardship declaration and file it with the court or an agent, you can file it with your servicer, you can file it with the bank, you can file it with the court, the proceeding will be stayed until at least May 1st, 2021. And then if you did not file it with the court, but you happen to have served it or mailed it to your servicer or the bank, that agent is required to promptly file it with the court and advise the court in writing of the index number of all the relevant cases, foreclosure actions that are going on, that you filed a hardship declaration for. But again, we would recommend filing it with the court as well. But in case you didn't, in case it just got mailed to your servicer or bank, those agents are required under law to file with the court and let them know that they have been served with a hardship declaration, and everything is stayed until May 1st. Next slide, please. In any action to foreclose, in which a judgment of sale has been issued. So maybe you're very, very far along in the process, and the bank has already obtained a judgment, what's called a judgment of foreclosure and sale, and there's an auction maybe pending. This law also covers you. It is not too late. In the first instance, the court cannot schedule that auction and have your property sold until the court has at least held a status conference with all the parties. But further, you're entitled to file the hardship declaration. And again, if you file it, it will stay any execution or auction at least through May 1st, 2021. So again, we encourage you to do so. Next slide, please. In addition, there are other types of foreclosure actions that go on. When people fall behind in their taxes, there can be a tax lien sale. And this often happens at around this time of the year. Many of our agencies are reaching out to homeowners to say, hey, you're a couple of years behind on your taxes. Did you know that the city of New York is about to sell your tax lien? They're about to sell it to a third party. Under this law, it prevents all local governments from engaging in a tax lien sale or a tax foreclosure against your property in general. This is huge because right now, as I say, this would have been right before the spring, would have been when the city of New York would have been often selling tax liens of thousands of homeowners to third parties who would then foreclose on these homeowners. This is all right now put on pause. And any property owner, again, who files a declaration, they can have a tax lien foreclosure by the city of New York or any other local government filed against them. But the tax lien sale now won't take place in 2021, which is a huge pause for homeowners and a great benefit. The amounts, of course, are still due. You will have to pay those and work out those back taxes with the city or local government where your home is at some point to avoid foreclosure. Regardless, you will not have a foreclosure tax lien right now. The other thing is that many people 65 and older and those with certain disabilities have tax exemptions that take taxes off their bill, and they pay lower taxes, and you have to renew those annually. You do not have to renew them this year. They will be automatically renewed into the next year. So you don't have to worry about sending in that renewal this year, although by all means do so that you don't fall into trouble, but you don't have to worry about losing that exemption. Next slide, please. Okay, again, this is just to remind people, similarly as to the one before, that the law applies to any and all foreclosures, as long as you're a natural person and you're holding title to a property or a series of properties that have 10 or fewer dwelling units in them. Next slide, please. The submission again of the hardship declaration, unless it's withdrawn by the owner, it will stay all entities. So sometimes there's a third party who comes along and says, I own your tax lien. This also applies to them. As long as you have filed that hardship declaration, nothing can be commenced against you at least through May 1st, 2021. Next slide, please. And this is extremely important also, and it was a very important piece that the legislature put in. Often when you fall behind in your mortgages, or there is foreclosure or tax liens filed for any particular reason, you are going to have that reflected in your credit. with the three main credit bureaus. This prohibits any lending institution, first of all, from discriminating against you in determining whether credit should be extended to you in general. So if you are going for a mortgage, you're going for a modification, you're going for a new home, the fact that you had filed a hardship declaration and had a pause until May 1st cannot act as a reason for a lending institution not to extend you credit. And further, it prohibits all negative reporting by any of the three or any credit reporting agency due to the fact that you as the owner had been granted a stay of the mortgage foreclosure proceeding, the tax foreclosure proceeding, the tax lien sale, the fact that you're in arrears and you filed a hardship declaration with your lender. All of those events cannot be used to negatively report on your against your credit. And if they are, you should contact one of us, immediately contact 311. You may not see it for a little while, but if that occurs and somehow it affects you negatively, you should reach out. Thank you.
Okay, thank you so much, Michael, Kara, and Donna. If there are two words that you got out of that, it should be hardship declaration. It's such a critical tool for tenants and homeowners right now to call a timeout, to stop that impending bad thing from happening. And it's such an important way to do that. So speaking of the hardship declaration, next up is Jenny Laurie, from one of my favorite nonprofits, Housing Court Answers, and she's going to walk us through the tenant version of the hardship declaration through a tool created by justfix.nyc. So Jenny, turn it over to you. You might be muted, Jenny.
Better?
Good, we got you.
Sorry, when I switched over to the website. Thanks again to Borough President Donovan Richards and others for hosting this town hall event tonight. I'm going to walk through, I'm not going to explain it much because the previous speakers have really done a great job of talking about what the hardship declaration is. Tenant groups, the Right to Counsel Coalition and Housing Justice for All Coalition worked with JustFix NYC, which is a nonprofit, to create this web-based tool for filling out a hardship declaration. And so tenants can use this hardship declaration to fill out the form. The tool will send the form by certified mail for free to the landlord, as well as email a copy to the housing court in your borough. So I'm just going to quickly go through the steps in this, and so people can see how simple it is. Before starting to do the form, you need to know your phone number, your home address, your landlord's name, and your landlord's address. If you have an email address for the landlord, that's great. And if you have a housing court case, it's great if you have the papers in front of you because you'll need the index number from that. Once you get to this screen, you've got to create a basically a login. And I'm just going to put in a number. That's obviously not real, but. And then you just go through a really simple tool. I live in Queens, New York. The tool needs to know which housing court to send this to. That's why I have to do that. I'm going to use a familiar address here. I'm going to say I live on the first floor. of 120-55 Queens Boulevard. Some of you may recognize that address. And I don't have to have an email address. So a lot of tenants, especially elderly tenants, don't have an email address, or if they do have an email address, they don't check it. If they do have one, it's great. This way they can use their email address to get the document and to send the document again if they wish, but you don't have to fill that out. And we're gonna set up a password. And then also I have to agree to a couple of terms. One is that my information will be shared. If you don't want your information shared, you can uncheck that. And then I agree to the terms and conditions of the website. And this is the really important part. We've heard a little bit about these two provisions in the hardship. There are basically one section covers if you have to move. So you're just stating here that if you have to move, it will create a significant health risk. And the other provision is that you're experiencing a financial hardship, and that maybe you can't pay the rent because you had to leave your job because your children are at home, or a member of your family died, you lost work, you lost pay. So you have to pick one of these. They're very broad descriptions, and they cover almost any situation that's COVID related. And here, if I have a court case, I say, yes, I have to put my index. I don't have to, but I can put my index number in here, and that will go on file with the housing court. So the housing court will know that I filed this, and it'll be in my file when I get to housing court. But if I don't have a housing court case yet, I can file this now, and it will prevent the landlord from filing a case against me until May 1st, or until the law allows. And here you just very simple, write in your landlord's name. And there's even some ideas here about how to get that information. And I don't know my landlord's email address, but I do have his mailing address. So I'm going to go here, and I'm not really doing this obviously, but so this just warns me that this is not a real. So I'm going to say my landlord lives upstairs from me. And so, so he's on the second floor, I'm on the first floor, and 3-4, is that right? And then this, we're almost at the end. These are the legal requirements for the form. I just have to say that I understand that I'm obeying my lease, that I may owe rent, that I may have to pay it later, that I may get a civil court judgment against me, and some other legal reminders that I have to read through and understand before I sign this. And then at the end, it's just the tool is going to tell me what I agreed to already, what I signed, what the document's going to look like when it's sent, and then I can look at it. I can click on this and see a PDF of it. I do have to say that I'm signing this for myself, and that I know it's against the law to lie on this form. And then I'm sending that, and hope it's going to send. Yeah. So, and then this last page on the tool is really great. It gives you your tracking number for the certified mail form that's being mailed to the landlord. It allows you to download another copy if you'd like. It also gives you 311 and how to call the tenant hotline, tenant helpline, which you've heard about today. It has here our phone number for housing court answers, and we can talk to folks about what's in this form and how to serve it if they haven't already. And it also allows folks to get a list of organizations that might work in their neighborhood that can help them organize a tenant association or get some legal assistance if they need that. The last thing I want to say is that this form is in English and Spanish, but there's also other language options that are links to other websites. And there are a number of different websites that allow tenants to fill this form out in not every single language in Queens, but a lot of them. So there are a number of different options for that. So, and I know that's important for Queens. So that's it. And I urge folks to spread the word about this hardship declaration, because for those who fit into the circumstances, it will protect them from eviction until after May 1st. And that's really important now. And thank you.
Thank you so much, Jenny. And again, the website is justfix.nyc. This applies for tenants. For homeowners, unfortunately, there is no similar website, but we understand that the courts have sent by mail many thousands of the hardship declarations to homeowners in foreclosure. So for now, it's evictionfreeny.org. That's where you find the Just Fix hardship declaration tool. So we're up to the end. The next speaker is my former colleague, Rachel Hannaford from the State Attorney General's Office. And she's going to speak about some of the things that tenants are facing right now, which is general abuses by landlords, including the failure by landlords to return security deposits. So I turn it over to Rachel Hannaford.
Thank you very much, Satish. Yes, we were indeed colleagues many, many years ago. Feels like too long ago. Thank you to the borough president, to Satish and all the panelists. It's really wonderful to be here. And I know I speak on behalf of my entire office when I say we really appreciate this opportunity to present to you and to give you a little more insight into what we do with respect to tenants' rights. You may not know this, but the Attorney General's office has a history of working to protect tenants against abuses by landlords and other real estate developers. And in recent years, we've brought a number of affirmative cases trying to really make a mark in the industry and signal that, you know, landlords and other real estate developers and people with an interest in those developments cannot abuse the legal rights that exist for tenants. I am a senior enforcement counsel in the Tenant Protection Unit. I'm sorry, not the Tenant Protection Unit, the Housing Protection Unit. That's Tenant Protection Unit is part of another state agency called the DHCR. But speaking of DHCR, my office does work hand in hand with DHCR's Tenant Protection Unit to identify and try to resolve legal issues affecting tenants, especially we have a focus on rent regulated tenants, but we certainly are interested in enforcing laws that protect all sorts of tenants. So you've heard wonderful presentations about the new laws concerning the eviction moratorium. And just so you know, my office has jurisdiction to investigate and, if necessary, you know, go after any bad actors who are trying to abuse that law. To the extent that these very rigid and necessary protections aren't being followed, I would encourage you to let your legal services offices know, let these wonderful people who presented know, who can bring that to our attention so that we could potentially look at, you know, reaching out to abusers and violators of the law. Satish mentioned that I'm going to talk about security deposits, which I will do. And I just want to also add that, you know, I hope you consider our office another example of a resource for tenants and also homeowners when it comes to getting an understanding and understanding their rights. I'm just going to bring up our website so that you can see all of the resources we have on the website, including the security deposit mediation tool, which I'll talk about. So our office, as you can see, has a guidance on the COVID resources, warnings, and consumer scams. And if you click on that link, you'll see that you can select by topic. Of course, our office is so big, we not only protect tenants, but we also protect all sorts of consumers, investors, small business owners, workers. And you're able to scroll down here and gain some knowledge about what these new laws can do with respect to those individuals. But if you click on tenants' rights, you'll see we have various resources that answer questions about the eviction moratorium, also the federal laws that are in effect protecting tenants during COVID. We have information about harassment, which has been talked about previously, unlawful eviction, and other things. You can just click on any one of these links and you'll find resources. I also want to mention that we are also an agency that investigates discrimination, including source of income discrimination and any housing discrimination. We have jurisdiction under the New York State executive law to investigate and go after landlords who are discriminating, either based on source of income, which is now a statewide protection, or any other protected category under federal, state, and local law. So to the extent, the discrimination we're talking about is it's kind of discrimination protected by the New York City human rights law, we have jurisdiction to investigate and go after wrongdoers under that law, as well as federal housing law. So I just want to let everybody know that this website exists. With respect to security deposits, if you go up to resources here and go into our complaint forms, you can see that we have several complaint forms depending on what you want to complain about. Under housing, we have this rent, security deposit, and apartment fee complaint form. So no one has mentioned this yet, which is surprising because there's a new law as of 2019, which the Housing Stability Tenant Protection Act did a host of things that are really helpful for tenants, especially tenants, low-income tenants and tenants who are more vulnerable to abuses. The one small thing it did with respect to security deposits is actually probably not that small to many people, which is it required that landlords return any security deposit from a tenant who's leaving their apartment within 14 days. And to the extent the landlord deducts any of that deposit for repairs, out of the ordinary repairs, the landlord's required to give the tenant an itemized list of what was deducted and why. If the landlord doesn't do that within 14 days, then the tenant is automatically entitled to their entire security deposit back. That 2019 law also made it illegal for any landlord to require that a tenant pay more than 1 month's rent as a security deposit, and pay more than $20 as an application fee. So because of this quick turnaround of 14 days, there have been a rise in complaints about landlords failing to return a security deposit in time. Before 2019, a landlord could take their time, and I think the law was just they had to return it within a reasonable amount of time. Now it's strictly 14 days. If you have moved out and your landlord hasn't returned your security deposit within 14 days or provided an itemized list, you can fill out this form. And our Bureau of Consumer Fraud will receive this form and you'll get a letter from us quickly. We will also engage to the extent necessary in any mediation. So if you are reluctant to go to small claims court, which is the other avenue where you could go to get your security deposit back, then our office is a good tool to interact with your landlord or have some government assistance in reaching out to your landlord if they're not following the law. That's about it for security deposits. I just want to mention one other thing before my time is up. And that is the unlawful eviction law of 2019, so in 2019, another thing the legislature did, which was a big change, was they criminalized unlawful eviction, or they expanded, I should say, what constitutes an unlawful eviction. And basically right now, it's a Class A misdemeanor to evict a tenant unlawfully, which includes self-help eviction, changing the locks without going to court, or any other sort of harassment which leads to eviction. And this is new because in the past, the criminal law only criminalized eviction that involved some sort of bodily harm or violence. And of course, it was very hard for prosecutors' offices to prove and find cases where there was actually physical violence during an eviction. Now, prosecutors' offices, including to the extent we get a referral, my office, could bring a criminal action against a landlord or a landlord's agent to the extent they unlawfully evict a tenant. So obviously, as has been discussed before, if you're unlawfully evicted, you have some immediate concerns that do not include calling my office. But you can reach out to your local police department, as was mentioned before. You can reach out to a lawyer or call 311. And to the extent you were evicted unlawfully, it is possible that either your landlord or your landlord's agent could be charged with a crime. And we hope that that deters some unlawful evictions that are occurring. Obviously, the only way to tell if there is such deterrence is to get such deterrence is to bring these sorts of cases. And so to the extent anyone listening or any of the legal services providers listening know of such cases, please let us know about it. And with that, I'll just end my presentation, but happy to answer any questions. And also, just to all the legal services offices out there, please feel free to reach out to me personally or anyone at my office, because we're always interested in hearing about trends in general, if these laws are being abused, or if you know of any particular large-scale practices that affect tenants. We're very interested in hearing about it. Thanks.
Thank you so much, Rachel. We're so proud of the work that the Attorney General's office and your team have been doing on behalf of the residents of New York State. So now is the time for the Q&A from the audience. I see no questions. I think we were so thorough and so complete that we preemptively answered any and all questions and concerns. And I did answer some in real time. So I will say that. So with that, let me thank the panelists. We really did have such a broad group of people from many city and state and nonprofits who really care about the people of New York State and New York City, and in particular are here, like we are at Legal Aid, for the residents of Queens. So we do have a question, but let me ask a question to the entire group just to kick it open for a discussion. So what is the most critical thing for tenants and homeowners right now? What do they need to do? What do they need to be aware of to navigate through this pandemic into the foreseeable future?
Well, I mean, this is Donna. I think you said it earlier, Satish, which I think and some of the other panelists did too. I mean, affordable housing is so vital to all of us and to Queens residents and to the communities we all serve. And I think the most important thing for tenants and homeowners to know is there's lots of resources out there. And that you should get to them. You should, if your landlord or your mortgage company or anyone else is telling you that there's not resources out there and they have to move, or they're gonna be in trouble, that they really seek it out, whether that's calling Legal Aid or 311 or Office of Civil Justice or any of us. but that really that there's lots of laws that protect and there's lots of resources.
Yeah, I think that's a great answer. And all of us are here and we represent many of those resources. The next question from the chat from one of the members of the audience is, should I pay my rent right now? So what do all of you think about that question?
If you can pay your rent right now, you should pay your rent right now. Unfortunately, there is still no such thing as cancellation of rent. And so we are currently in a position where rent is still due every month. We understand that there are a lot of people who are facing challenges paying their rent. And if you are in that position, please reach out to one of the many resources you have heard about here today, and we will help you come up with a strategy moving forward and prepare you for any case that ends up being brought against you. But the short answer to your question is yes, if you can pay your rent, you have to continue paying your rent.
Yes, I think that's a great answer. The rent will be coming due, and at some point, the landlord can still seek that money in civil court. So there may be a collections case coming. There is no cancellation of rent. So people should be very clear about that point. So to the organizers at the Queensborough President's Office, several people have asked if we could make all of the presentations available to the public. And so we are happy to share our slides, and I'm sure all of you are as well. So we will send them to the Borough President's team, and perhaps they can make them available as one set of documents to everyone at the website. So next question is, what happens if a tenant, excuse me. Next question is, if a tenant moves out after the lease expires and owes money, what happens next?
Well, I mean, this is Donna. It's just what you all said. I mean, it is if rent, and it can be a complicated question depending on the facts. But if money is owed, I mean, and to a landlord, then a landlord has options to seek that. It may, once the person moves, it may be in a different court. It may not be housing court. Once the person moves, it may be civil court or small claims court, depending on the amount. But there is still the availability of a court action to obtain any back rent that may be due under a lease or any other contract.
There is a duty to mitigate now, which is in the law, and that requires a landlord to try to find another tenant to take over if a tenant breaks their lease. But the current circumstances are that many landlords are having trouble finding tenants, and vacancies are up in New York City. So we'll see what the courts say on that issue, on the landlord's duty to mitigate when a tenant breaks a lease. But generally, I think what Donna said is very important to note. The money still may be owed. The landlord may still sue you for the money, even if you moved out for a good reason, if there's still time left on your lease.
And maybe I will just answer also, because I represent older adults and older tenants. There are some circumstances where, under the law, where certain people can break a lease. And certainly there's some that protect seniors and people with disabilities. If you have questions about that, if it happens to fall into that category, you should reach out to us and we can answer that.
Okay. We have another question from a mortgage holder who received mail from the attorney for the landlord, I believe, and hasn't opened the letter yet, but is kind of nervous about what may happen. So first piece of advice is open the letter, look at the mail. I know that it's often easier to ignore it and hope that it's not bad news, but these letters really matter and they have legal significance. So if you receive a letter from your landlord or the mortgage holder for your home, or really, any governmental agency, open the mail. And from there, maybe you can call one of us and seek help with whatever the issue is that's presented in that letter. Maybe it's just a holiday card, who knows? And you have nothing to worry about, but maybe it's a notice that says they're going to try to take you to court. And if that's true, depending on your situation, you may be able to file a hardship declaration like we described here and give yourself some breathing room, call a timeout on the situation, and explore your options between now and May 1st.
Satish,
Yes.
can I just echo what you're saying about the need to respond and, excuse me, that folks should know that there are resources out there to help them respond, particularly in the context of a court proceeding in housing court. One of the powerful aspects of the city's right to counsel law is that tenants should be aware that at court they will not be alone, particularly now in the midst of the pandemic. One of the things that we've been doing is working closely with you providers and with the court to ensure that when unrepresented tenants are actually scheduled for appearance, that they're able to meet with legal resources there. Again, either by way of a teleconference or, if they're in person, connecting with the court and legal provider right then and there. I think it's just really important to know that, as you say, open that envelope, look at those papers. And if the papers say you've got to be in court or respond to a court process at a particular time in a particular place, we've made sure that there's also information there to talk about how to access legal help beforehand. And you shouldn't wait. You should take advantage of it. But even if you do wait, and you actually are appearing in connection with a court proceeding, the right to counsel is there to help you, and OCJ's legal services are there to help and protect you, whether it's delay or outright resolution of the case. That's what they're there for, and that's what makes the city a special place. Anyway, just want to echo the importance of being able to respond.
A follow-up question is, homeowner is able to pay the mortgage, but can't pay the maintenance. So it may be a co-op. Are there resources available to help homeowners pay maintenance that's accumulated over the past year?
I'm not sure if we do that.
I don't know if the city wants to answer that. I will say just there are resources, and then I'm going to let Jordan answer that. But co-ops are covered under this law, and for the hardship. So the first thing is that if you're having a hardship and need a pause, often co-ops were left out of a lot of different laws, but they happen to be included in this one. So that if you're having problem with paying your maintenance, you can do the hardship. You should be able to do the hardship declaration. But as to how you pay that and what resources out there, I'm gonna send that over to Jordan.
Thanks, Donna. And I'm going to send it over to my colleague, Kenneth Charles, who's here from the city's Human Resources Administration. My office is a part of the Human Resources Administration, which is itself a part of the Department of Social Services. Kenny?
Yeah, sure. I was sitting here thinking, I don't know if I've seen that, but I'm always interested in new HRA issues. So I would suggest that you apply for rental, for cash assistance, arrears. Because we play arrears, as you guys know, and I would ask someone to apply for it.
Yeah, that's great advice. When in doubt, put in an application.
My suggestion to everyone, when HRA is involved, always apply.
Yeah.
Don't sit at home thinking you don't qualify for something. But that's a good one. I would like to see what happens anyway. I would love to see that person apply for it.
Yeah, I think, correct me if I'm wrong, but it's safe to say that right now in these dangerous times, people are eligible for assistance in many new categories that we never considered before. Is that fair to say?
Right.
Okay, great. Thank you.
Certain properties involved, the deeds may be involved as part of the application process. But.
Right. There may be more paperwork given that this person seems to be a homeowner or a co-op shareholder. Here's a question for Hannah. Do the laws that you described relating to repairs apply to someone who lives in a private house and the owner of the house doesn't make the repairs?
They absolutely do. They absolutely do. Everyone, every landlord that has entered into a lease agreement or in which you have remained in the apartment for at least 30 days has an obligation to provide habitable housing. This warranty of habitability that I was talking about does apply in private housing as well.
Great, yes. That's really, really good to know. It really almost doesn't matter what type of housing you live in. If you're renting from someone or a corporation, or the landlord lives upstairs, they still have an obligation to make sure your home is safe, healthy, and habitable. So a couple more questions, and I think we'll turn it back over to the closing remarks from the Borough President. I'm going to sum up a few questions as follows. What about landlords? What about landlords who have tenants who can't afford to pay the rent or submit hardship declarations? That's basically the question, and I'm editing a little bit.
So it's from certain perspectives. One, if you're falling behind on your taxes because of that, or your mortgage, one, you can do the hardship declaration and have a pause on that. Additionally, and we did not go into this tonight, but if you're falling behind again on your taxes or your mortgage because you have your income has been affected because your tenant can't pay you. There are other forbearances, modifications, there's other resources and loans available to homeowners out there, and you should contact one of our legal services office or 311 or one of the organizations that represent small homeowners for assistance. Don't wait. Okay.
Related to that, can landlords apply for HRA assistance on behalf of their tenants?
No, not in behalf of. Go ahead, Rick Jordan. Yeah, no, not in behalf of each tenant, unless the tenant authorizes it with an authorization form, you can do that. But it's a line that we try not to cross.
Okay. So what would you suggest is the landlord's best course of action?
Jordan?
Satish, if I could, I think sharing some of the information that's been discussed tonight about the resources available. One of the things that's happened in housing court with the introduction of the right to counsel with so many legal services providers representing tenants is that in many cases it's facilitated good outcomes to cases because a tenant who may not know all the resources that are available, whether it comes to emergency rental assistance or ongoing rental subsidies or just, plain vanilla cash assistance and even SNAP, those connections are made. The tenant is on a stronger footing and the tenancy can be saved because in many cases, the objective of a landlord is not to get rid of that tenant. It's just to make good on the rent. And sometimes a helping hand is what's needed there. So my general recommendation would be to share resources with tenants like the tenant resource portal, like the tenant helpline that's accessible via 311. And of course, because it is legally required, the information about the hardship declaration, if that's what's needed.
Okay, I think we've covered all of the topics in the Q&A. So let me take this opportunity to thank all of the panelists, starting with Jordan and Kenneth from HRA, and Juan and Olivia from the Mayor's Office to Protect Tenants, Hannah from NILAG. I want to personally thank Michael and Kara, who are law students who put a lot of time and effort into putting together their presentation. Donna from JASA, Jenny Laurie from Housing Court Answers, and Rachel Hannaford from the State Attorney General's Office. And with that, I'm going to turn it back over to Borough President Richards for some closing remarks. Thank you all. I think this event went really well and we conveyed a lot of important information. So Borough President Richards, it's back to you.
He's gone.
Stand by, please.
So
Well, we'll try to get him back. Our office just would like to thank all of you for taking the time to provide such
Thank you.
important
All right,
information.
hold on. I'm coming back on. Sorry. I'm juggling two Zooms and I'm on. I have young people on a Black History event who are asking questions. The panel is on Black elected officials for Black History Month, and so I couldn't skip out on them tonight, you know, when young people call. But I want to thank each and every one of you for showing up tonight. And I want to thank you, Satish, because I think I might have butchered your name early. I think they wrote it wrong in one spot and then wrote it right in one spot. But I will take the responsibility for that. So I want to thank you for all of the information that you provided tonight. And I want to thank each and every one of you, because I thought that we've been on for nearly, I think, 2 hours, but I was flicking back and forth, and just the information provided is so critical. I mean, so I don't have to tell you this, but for those of you who are listening tonight, this information is so critical for how you fight and battle the challenges that we're going to face ahead. So I really implore each and every one of you, if you got information tonight, to make sure that you're passing that on as well. If you know of anybody with challenges, our office number is 718-286-3000, and you can call here, and we have people here who are going to work on your cases. Which was very interesting. I was walking out of the cleaners very early this morning, and I was a lady was coming out, and she said to me, "Are you Donovan?" And I just want to tell you this story because it speaks to the work that these individuals do every day. And she was living in a homeless shelter and was being evicted at the time because she had made just a little bit over whatever the threshold was. But she broke down crying, in front of the cleaner, saying, "Thank you for helping me, because your office assisted us in helping me during that difficult moment. And I was able to find my way out of that darkness and into a period of light because of the assistance that your office gave." Now, it wasn't just my office. It was one of these organizations that my office partners with on this line today that helped us to navigate that tough situation. So I want you to know, if you are struggling tonight, that you are not in this alone, that there are a lot of people in your same predicament. I've been in your predicament. Like I've had to couch surf at one point in my life. My parents we had to move everywhere, because them eviction papers were coming. So the best thing we can do is to make sure that we don't feel alone and sit in a corner and think there's no assistance here. These organizations are here to help you. We're going to be focused on this. I love, Satish, that you mentioned the right to counsel, because the right to counsel should be expanded across the entire borough of Queens. There are certain community boards that had that, but we need to see more legal assistance ramped up as we move forward, because we know that Pandora's box is coming and we just have to be ready. So I want to thank each and every one of you for being here tonight, for sharing your information, which is vital during this period. And we look forward to a continued partnership with each and every one of you. And thank you. Just want to say thank you. So Satish, I don't know if you'll have the final words, but I want to thank you and thank all of the agencies and organizations who are here today for the work that they do. So thank you. Thank you.
Thank you so much, Mr. Borough President. Thank you for your leadership. And again, thanks to everyone who participated in this. And